motions on both sides with respect to that issue. I will further note that none of the parties have requested oral argument in their pleadings on those motions, so I am prepared to rule. And I'll just note for everybody else present in the courtroom sort of the procedural posture that we're in with those motions. In support of their motions to strike the defendant's anti-SLAPP motions, plaintiffs argue that the defendant's anti-SLAPP motions are untimely because they are procedurally improper. Specifically, plaintiffs argue that Oregon law requires the defendants to file their motions, specifically their anti-SLAPP motions, prior to filing their answers to the complaints, or to the complaint in this case. Here, defendants filed their motions after filing their answers. For the rule that the plaintiffs put forward, they cite Horton versus W Protector Insurance Company. The case cite for that is 217 443 2008. It's a 2008 Court of Appeals case. And that case does hold exactly what plaintiffs argue that it holds. Specifically, that to be timely, an anti-SLAPP motion must be filed prior to the defendant filing his or her answer to the complaint. That did not occur in this case, and accordingly, I grant plaintiffs' motions to strike the anti-SLAPP motions of David Willis, Christopher Ponte, Mackenzie Lewis, and Ian Kramer. And counsel for plaintiffs preparing orders to that effect for my signature. I will note that I did consider the defendant's arguments and filings in opposition to that motion to strike, and I'll summarize what I took from those arguments, which is essentially that I should exercise my discretion to disregard the Court of Appeals holding in Horton because the case is poorly reasoned and consequently bad law. I do not have the authority to do that. Horton is binding precedent on this court because it is a Court of Appeals case, and I cannot disregard a Court of Appeals decision even if I disagree with its reasoning. The case directly addresses the issue in this case and decides that issue in plaintiff's favor. So my holding is in accordance with that Court of Appeals holding. Any questions on that? All right, no questions. We'll move on to defendants Gibson and PATRIOT Prayer's anti-SLAPP motion, which was filed in a procedurally correct and timely manner. Before we begin on that, though, and Mr. Buchel, just to give you the heads up, of course, we'll start with you because it is your motion. But before we begin, I'll let everyone know that I'm prepared to rule on that motion today. And I have read all of the legal filings in this case, and as a result of that, the filings are well written. I have a good grasp of the legal issues. I've also done my own research into the case law that's applicable, so I'm prepared for the oral argument today. I understand all of the legal issues. There are voluminous filings in this case with regard to the evidence, and I have not finished reviewing all of the evidence in this case, and I want to make sure I do that before I rule. Part of the difficulty in my reviewing all of the evidence in this case prior to today's hearing is not only its voluminous nature, but also the fact that the evidence was filed in piecemeal fashion on an ongoing basis rather than all at once when the filings were made. I think that the parties are procedurally entitled to do that, so I will consider that evidence, but it does make it somewhat inconvenient for the court to prepare for an oral argument, particularly when some of that evidence was filed yesterday afternoon. So I have not had a chance to look at that evidence that was filed yesterday afternoon because I was doing other things in other cases yesterday afternoon. So I do want to make sure that I have time to review all of the evidence. This case merits that attention, and I will do that before I rule. So what I intend to do is hear oral arguments today, and before we conclude the proceedings today, the proceedings are scheduled to take until 11 o'clock, and we can use all of that time if we need to. I will schedule a time for everybody to come back in approximately 2 weeks, and I'll orally rule at that time from the bench. So I don't want to keep everybody waiting any longer than that. So I should be able to review all of the evidence in that time, and also meet my other obligations in other cases. So that's just sort of a roadmap of where we are. Any questions so far? All right, Mr. Duke.
I have prepared a presentation of approximately 1 hour, maybe a little less. Do we have flexibility to go after 11?
We don't have a ton of flexibility to do after 11 o'clock. I have another matter scheduled at 11 o'clock. We can go a bit past 11 o'clock. Let me ask, Mr. Chavez, are you going to be presenting the plaintiff's argument today?
I am, Your Honor. I don't suspect our presentation to be longer than half an hour. That said, we would appreciate every bit of argument time that we can. And if the defendants do go over an hour, we will require more time.
Okay, all right. So, Mr. Buechel, if you could keep your presentation to in between 45 minutes to an hour, I think that will leave enough time for the plaintiffs to have enough of their time that they're asking for in order to respond. To the degree that we can't finish with argument today, I am prepared to set aside additional time another time to conclude oral arguments, but of course that will delay my decision in the case. It will also delay the case going forward if it doesn't go forward after today. So just everybody keep that in mind. So with all of that said, Mr. Buechel, I'll turn to you when they present defendant's argument in support of your anti-SLAPP motion.
Thank you, Your Honor. There's no dispute that this is a political case, and Mr. Armstrong is a leader in the Antifa community. He makes his bar a support to Antifa. There's no dispute that Mr. Gibson regards Antifa's political objectives as threatening America's future. There's no dispute that Mr. Gibson organizes events on Facebook and people come to them. There's no dispute that the Antifa people are committed to deplatforming these events. There's no dispute that this particular thing, the Cider Riot May Day after party, hosted by Cider Riot and Rose City Antifa, was not an event hosted by Mr. Gibson. It was someone else's idea. And we now know from the evidence that's coming toward the end of the case that part of the work of Cider Riot and the plaintiffs has been to work to build a case targeting Mr. Gibson, even using this undercover agent who says, after filming what happened today, he's going to come back to Cider Riot. And we know that they had intelligence so that they all ran out of the bar to meet Mr. Gibson even before he arrived, armed with the mace and the batons and the brass knuckles and wearing their masks and even the plaintiff masked up. And we now know from the redacted portion of the OLCC report that they destroyed all the videotapes inside what happened that day. They promised to provide them to the police that night, but then they erased them all because then we would know who was there, what they did, and there would be an ability for Mr. Gibson to defend himself by singling out some of the people who were violent to him and so forth and so on. And so the way they approach this thing shows that they're misusing the judicial process of the court, and less than 48 hours after this happens, bang, lawsuit's filed. It's a classic strategic lawsuit against public participation. Now, I understand why Mr. Gibson would draw this attention. In any period of political conflict, there are always complaints about outside agitators, agents provocateurs, or whatever. There's always attempts to hold them responsible if something goes wrong. And something did go wrong, and we'll get to that. But because the political demonstrations occur in public, whenever they involve views that are unpopular, they will involve a risk to public order. And the puzzle of this case and its importance is what happens when a group like Antifa routinely uses violence to shut down opposing views to the point where Mr. Chavez draws the analogy of a hornet's nest. Well, Mr. Gibson came and stuck the stick in the net of hornets, okay? And it's true as a matter of tort law, if someone sticks a stick in a net of hornets and people get bitten, maybe that's a tort for the people who got bitten. But the Antifa members, they're not insects. They're human beings with free will, and they have the right, the free will, to ignore Mr. Gibson, to choose to respond non-violently, or choose to respond violently. And we'll see that's what they did. And the rule of law they seek would use tort law to say if you exercise free speech rights against Antifa and some sort of violence ensues, you will suffer some crippling award of damages. Even if you weren't someone who threw anything or hit anybody or sprayed anybody. And so the question is, Can Antifa be allowed to shut down speech by becoming violent just because someone appears and starts filming them and talks to them? This is an important question because First Amendment law has traditionally required sort of an objective standard. How does the reasonable person respond? Not some sort of hypersensitive criminal gang. And it's important because, again, they're trying to use their propensity to violence to shut down free speech. Now, the four torts under Oregon law: negligence, trespass, IIED, and intentional interference with economic relations. I want to argue that they all have the First Amendment and a judicial role built into them, that they involve important questions of law that are inextricably intertwined with the First Amendment. We know with respect to the intentional infliction of emotional distress, they have the burden to show conduct extraordinarily beyond the bounds of socially acceptable behavior. And we know that the court plays a gatekeeper role to determine beyond the farthest reaches of socially tolerable behavior. That's the gatekeeper role which the court finds itself in today. And the intentional infliction or the intentional interference with economic relations tort, same sort of thing. Improper means and an improper purpose. And what is proper? What is proper? That is a question of law for the court to decide. That the Antifa people doesn't think that objections to their views are proper, but the First Amendment tells us that political objections are a proper purpose. And so the court has to decide, what does the First Amendment require us all to tolerate? And these are all questions of law. Now, turning to the negligence case, this used to be simpler. The question would be whether there's a duty involved. Did Mr. Gibson owe a duty to the bar? And now it's turned into something about foreseeable, unreasonable risks to a protected interest and a protectable interest. Now, we think that that's also a question of law, and again, the First Amendment answers that question. In America, we don't protect businesses against demonstrators who are unhappy with the business. We just don't do that, especially if it's political reasons. So there may be a legally protected interest in business revenues, but there's no legally protected interest in being free of political protest.
Let me ask you a question about that. I just want to ask a question about where the line is there that I should be looking for. Obviously, or maybe it's not obvious, and maybe I should start here. Not all speech is protected. There's a line there, isn't there? Speech incites intentionally, or maybe even negligently, others to act in a tortious manner. Can't the person engaging in the speech alone be held tortiously liable?
Well, the case hasn't been that well briefed, to be honest, and there is a line of fighting words cases that hasn't really been discussed. But again, that line, which began with Chaplinski versus New Hampshire and then moved forward to Terminello, Gooding versus Wilson, case like that, there was a high watermark where that was true. But I think by the time we got to Gooding versus Wilson, where someone says to the police officer, "You white son of a bitch, I'll kill you. You son of a bitch, I'll choke you to death." Protected speech in the context of a political demonstration, a political context. And so I think that the law has changed in that regard. And I think it also, that's the line of cases that talks about, a reasonable response. And so we have to look at what Mr. Gibson said and say, would this cause an ordinary person to freak out and throw the drink in or to spray him with mace or to throw things? That's what we have to look at under that line of cases. And I think under the Oregon Constitution, Article 1, Section 8, it's an even narrower question. And if we ever get to further briefing on that, this body of law that wasn't really discussed in the briefs, you'll see that there's cases where the Article 1, Section 8 relates to certain historical exceptions, and that's not really one of them. But we have a broader protection here in Oregon.
So, again, I think you answered my question, but I'll just ask it more plainly. So at what point does, if we're talking about speech alone, at what point does that speech cross the line?
I would say almost never, unless it perhaps constitutes a crime. I will give you $50 to go kill someone, okay? A crime of solicitation or something. There are crimes, there are historical speech exceptions, but nothing Mr. Gibson did comes near any of the historical exceptions. And I think we can see that from all the cases that we cite. There are I will say we have the cases of the Catholics attacking or harassing those witnesses. We have the environmentalists attacking the newspaper. People attacking businesses all the time. And I use the word attack or harass, you know, to demonstrate attack or harass the business the way the plaintiffs do, okay? They perceive the demonstration as an attack or a harassment. But that doesn't make it, you know, a criminal, you know, something that fits within the bounds of the criminal harassment statute or the criminal, you know, assault statute. That's what we're looking at. We're looking for something like that. And we've showed you case after case of protest leaders whose anti-SLAPP motions have been granted on First Amendment grounds. You know, we had the anti-communist Vietnamese protesters in California. And this leader of the protest is grossly offensive and personally attacking and